Mr. Derstine. Thank you.
I'd like to start off with the whole question about the gun legislation in Canada. Much has been made, not so much an oral argument, but rather a written argument about the necessity for gun control legislation in Canada and who could gainsay that. The question, however, about the fact about whether it is a coherent and rational structure which bears significant analysis in my submission is somewhat different. And I don't want to spend very much time on this, but I just want to draw your attention to a couple of places where I say that this legislation is less coherent and less reasonable than it may seem. One of the factors which has been raised by my friends, for example, is that the scheme of the legislation as a whole and the scheme of legislation as encompassed in Section 95 both deters and denounces. One of the things which I will develop throughout the course of my submission is that in my submission, Section 95 itself does not deter and does not denounce. Now, one of the things I would like to raise is, for example, no one would say, of course they could not, that firearms are not inherently dangerous, that perhaps we live in a better society than the United States because we regulate them strictly and the like. But I wish to bring forward, while we consider this whole barbarians at the gate idea about firearms and we need to protect ourselves, that, for example, that while guns as a percentage of crime is going up, clearly violent crime and specifically homicides are going down. As a matter of fact, I've included at tab 1. I won't take you.
Isn't this for Parliament to decide, though, this debate?
It is. I raise it only because it is so often during the course of these discussions a staple of the Crown submission that we have this overwhelming problem which we need to regulate severely. I just wish to bring a couple of things to the Court's attention. The first of them is that, of course, murder statistics are going down, and I've reproduced at tab 1 of my compendium the fact that in 2011, Jurastat said that the rate of firearms homicide was at the lowest rate in the last 50 years. So in my submission, the whole question about what exactly do we need to do to combat this pressing problem also must be borne in that particular light. The second thing is that during the course of the time while these initiatives were being brought forward to increase the mandatory minimums in Section 95 is exactly the same time that, somewhat paradoxically, the same government was reducing the control that we have over long guns and other forms of firearms by, for example, destroying the long gun registry, actually eliminating information that we had on those particular matters. Now, I really don't want to go too far into these matters. I appreciate very much, Chief Justice McLaughlin, your comment, but I couldn't resist, to a certain extent, bringing forward some notes to bring forward into this, because there very much is, in the Crown submissions, this whole idea that significant laws are necessary because of this avalanche of problem which is before you. Now, one of the things that I'd like to bring forward, which is, has already been touched on by some of you here today, is this whole question about harsher penalties do not have a deterrent effect. This is a matter which was the subject of evidence being called in the Noor matter. It may have escaped your attention. It doesn't form any significant part of the record which is before you, although we put it in our compendium. But there were days' worth of expert evidence called on this very topic. Professor Dube, who was at that time the chair of the Department of Criminology at the University of Toronto, and a couple of experts who were also called by the Crown on this particular matter, speaking specifically to the question about whether or not increased harsh penalties actually produce deterrence. And I would rely very much on the conclusions of Professor Dube and the many articles which I have put forward, some of them in the materials which are before you in my authorities, to the effect that they do not. The most telling and perhaps memorable account of this comes by Professor Dube, who said it's a bit like searching for Sasquatch, that eventually you have to look over every hill, and you could say to yourself, maybe there's a hill where I haven't found it. But eventually you have to say, we've been looking for it for 20 years. We just got to come to the conclusion that it doesn't exist. And that's very much the conclusion that Professor Dube brought forward. And that is all the more emphasized by the extraordinary amount of study which has been done on this particular question. Studies, for example, in California under the three strikes and you're out law, where overwhelming peer-reviewed macro studies found that there was no decline that could all be traced to this particular matter.
Does the efficacy of a sentence figure into the gross disproportionality analysis?
It may. It fits in on a couple of different questions. Clearly, the question about penological The reasons why it is that we impose sentence was specifically mentioned by Justice Gontier in both Goulds and Morrissey as one of the factors which needed to be taken into account. Clearly, obviously, it would have effect on Section 1, although I would be surprised, candidly, if that was really the battle place where we were actually going to be fighting all of these matters. The question always has to be raised during the course of any constitutional litigation: at what cost do we gain such a measure? At what is the price for the candle that we bring forward? But moving beyond the whole question about whether or not mandatory minimums, and to a certain extent I brought that up as much as I did because of Justice Bella's comments, but to a certain extent, Section 95 really reduces much further the possibility of deterrence because of the nature of the section itself. The whole rationale that is posited by people about why it is that a mandatory minimum sentence deters is because they say, let the hue and cry go out to the nation. If you touch this thing, you'll go to jail for 3 years. And in fact, we deem a knowledge in Canadians of the fact that they know the law, so they must know this, sometimes in the face of all evidence. But on the other hand, we cannot deem to Canadians that they will know the result of Crown election. Prior to the advancement of this particular 3-year mandatory minimum, you could get an absolute discharge all the way up to 10 years. After the mandatory minimum, you could get an absolute discharge all the way up to 10 years. There is no way that your ordinary Canadian could decide on the result of Crown elections. That you can't deem that. You can't say that they will know what's going to happen. So that your average Canadian, when they're considering nominally whether or not to commit a certain crime and considering the state of the law as they must know it, will not know what the potential penalty would be if they were to commit this crime. It would be completely obscure to them. They cannot know. So
have a pretty good idea if they didn't have a license and no authorization and no registration certificate, I would have thought, in most cases. When they're not doing anything for a legitimate purpose, I would have thought they'd have a pretty good idea.
That they would be receiving a significant sentence?
Yes.
I don't disagree with you, but the question here is the imposition of the mandatory minimum sentence of incarceration of 3 years. This Court and all courts of appeal, the Ontario Court of Appeal and all other courts of appeal, have been absolutely clear that gun violence is intolerable and must be strictly dealt with. There is no question of that, and nobody is suggesting anything to the contrary. The question here is, do we embark on this Procrustean bed of putting mandatory minimum sentences in order to achieve the virtue of deterrence? And my submission that the increase in the mandatory minimum sentence in this case cannot inform your average Canadian about the fact of the likely result of what is going to happen to him if he is found guilty of this, beyond the fact that generally he may be said to believe that he would be strictly dealt with. The ambit of this section has not changed. If we consider this, to use a rather flip example, if we consider Section 95 as a dinner roll, we've just replaced it with exactly the same size of donut. Right? There is no difference. The minimum remains, and the top end remains. The only thing that is changed by this is that we have taken a chunk out of the middle of the sentencing range. And in my submission specifically, and this point was specifically raised with the Crown's main expert on this point, and he specifically said that in those circumstances there could be no deterrent effect by the raising of this. So that the denunciatory aspect, it is still, as it always was, that you can go all the way down to the bottom and all the way to the top. Section 95 does not denounce. It allows for a huge continuum of what the possible penalties are, and it does not deter. And don't take my word for it. The Crown's very experts said exactly the same thing.
What was the purpose of the former government, not this government, the former government introducing this minimum to begin with?
Well, they were...
I'd like you to answer that, please, and also, if you don't mind, while you're there, tell me the difference between Justice Doherty's hypothetical now as opposed to then, and whether then he gets a year, whether that would be grossly disproportionate.
In my submission, it's always a little opaque to gaze into the question about parliamentary intention. But in my submission, clearly what they were trying to do is very much what the government of the day today is trying to do, and that is to say, to send out a deterrent message to other people. I mean, that's the nicest way that I can put it. It could also be said that we could almost take judicial notice of the fact that governments try to do things for a series of reasons, ideological and otherwise, which please various different constituencies and the like. But at a minimum, to use the various different words that were used during the speeches, is that they were trying to denounce and deter unlawful conduct by some. I point out, and this has been raised before, that the denouncing and the deterring of the unlawful conduct is at the high end of the spectrum of this, and the difficulty, as Justice Doherty found, is that it covered a wide swatch of things, very much as it did in Smith. But to answer the second portion of your question, Justice Moldaver, in my submission, it would still be grossly disproportionate. That if a person is still supposed to be getting an absolute discharge for something, but instead receives a year in prison, in my submission, that is still grossly disproportionate. Now, I would also say that the other difficulty about the question about mandatory minimum sentences, and I think that we need to a certain extent, as part of this conversation, say that not all mandatory minimum sentences apply in the same way. Right? The mandatory minimum sentence of 7 days is not the mandatory minimum sentence of 3 years, and is not the mandatory minimum sentence in Smith of 7 years. I mean, they're not the same thing. We can speak about them abstractly, but realistically, constructing an hypothesis about a doomsday scenario and a mandatory minimum, we also have to look at the nature of the sanction which is actually seen to be put forward. The larger the sentence that is imposed, the more it can bring forward potentially a grossly disproportionate sentence in my submission. The difficulty is about a grossly disproportionate sentence is if you have the top end of 7 days, it's much more difficult to come to that. And I'm tempted, I will take you to Goulds later on, but some of the analyses which flowed in my submission from the various different cases prior to this case here today are tied up, as they always are tied up, in the nature of the facts which they bring forward. Now, in my submission, the Ontario Court of Appeal was right to find that Section 95 breached Section 12 by way of a reasonable hypothetical. And you will notice, please, the fact that this is an ambit, this is a section which has an incredibly wide ambit. Don't take my word for it. That's exactly what Parliament seems to suggest by suggesting everything from 10 years in prison to an absolute discharge during the course of it.
Sorry to interrupt you again.
Sure.
I apologize. I really do, but I have to get this clear in my head. I heard your answer saying that the former regime would also be unconstitutional.
Yes.
And so my question is, how long was that regime outstanding? And was there ever a successful constitutional attack on it based on the kind of hypothetical that Justice Doherty has posed?
No, there was never a successful constitutional challenge on it. I don't have the specific time. I could get that for you if you needed it, but it was 7 years, 5 years, something along a number of years. Let's just put it that way. There was certainly ample time for a constitutional challenge to have been brought. It's always a little opaque, frankly, when tell you something. When I looked at the constitutionality of the mandatory minimums in Newer, I was surprised that nobody had brought a constitutional challenge to it. I assumed that I would open up my computer and find that there had been and there hadn't, and I was surprised by that too. Part of it, I suppose, brings out the fact that the more that you lengthen these things, the more it seems significant and the more it's going to go forward. You see, and that brings forward another aspect, and I'm getting ahead of myself, but I can't help myself. The whole question about how it is that we decide based on reasonable hypotheticals and whether or not we should use reasonable hypotheticals, it's not always easy to bring constitutional litigation. And the more that the penalty is severe, the more likely it is that the nature of that penalty will lead to constitutional litigation. Right? If you're only facing a one-year problem, you have problems, frankly speaking, from an absolute way. It takes a while, for example, to get up to Superior Court. You've probably got enough pretrial custody in. You may very well not get legal aid to fund your appeal if you want to go there because it's already moot. There are a whole series of reasons why it is that matters don't progress through the courts. But let me go back to a certain extent about the width of this provision, because it is very wide and it is very much like Smith, and it is to be distinguished in my submission from a number of the other cases that are going forward here. Now, the Attorney General for Canada, in their factum, said that there are no small-time offenders under Section 95. In my submission, that is not and cannot be correct, given the nature of the statutory scheme itself. The offence in Smith, although it was a very serious offence for the purpose of Smith, and it's worth remembering that Smith didn't actually meet the test for the reasonable hypothetical himself as a cocaine importer, but they used that particular test because they found it was a broad and had wide amplitude. Section 95 is exactly such an offence. It goes from people who are monstrously criminally culpable to people whose activities, in my submission, create almost no harm. And the Attorney Generals who have before me would certainly say, and have said in their factums, that there are no such people and that there is always harm. If that is so, I ask rhetorically, how is it that these people who have created such obvious harm, Parliament says, are entitled to an absolute discharge? The only people who are entitled to an absolute discharge are persons, in my submission, who have created no more harm than one could imagine. Very much like the person who comes into Canada with a joint in his pocket has presumably done some nominal harm to Canada by so doing, but not to any measurable degree. This is exactly that same sort of statute. So that when
another aspect of this, though, is that the criminal law often serves a preventive function, and
yes,
what's prohibited is bigger than the core of the harm that's really being addressed, and I guess the impaired driving is perhaps a good example of that, where with the presumptions and so on, a lot of conduct that seems quite a long way from actually driving while impaired ends up getting prohibited and for that matter, subject to minimum sentences potentially. So I guess where does the preventive aspect of this fit into the grossly disproportional analysis?
The question about the grossly disproportionate analysis, I suppose, is, in my submission, doesn't so much deal with that. The reason why, in my submission, something is grossly disproportionate is because it is far in excess. It is a sort of a horrible sentence given the degree of culpability. The reason why it is that you enact a statute, in my submission, like this one, and I agree that it is largely preventive, but the question of the gross disproportionality goes at the other end, allowing for the moment that it's a good idea to prohibit these things to prevent future harm, which in my submission is not questioned. The question is, what effect does it have? What, by the sanction which you ascribe to this particular motivation, what is the effect of that sanction, and how does that go to it? I mean, in Goultz and Morrissey, much has been made about those two particular tests, and I've included them in my compendium at those parts, but what is important in my submission to remember during the course of both of them is in both cases, Justice Gaultier was at some pains to recall that the example in Smith was correct. In Goultz, he said that the reason for that being correct was because it could easily be imagined and because it cast such a wide net. And he was at some pains in Goultz to say that the wide net was not duplicated in this particular section. That in the example that he had in Goultz, it was not a wide ambit. There were a whole series of things that had to be done, and that there were no small offenders, a phrase he specifically used. Whereas in the case at Barr, of course, there are small offenders. In Section 95, there are small offenders, and Parliament said so. Specifically as well, in Morrissey, the same thing occurred. He said again that the considerations which went into the one joint reasonable hypothetical were reasonable in that case for a lot of those reasons. I mean, in Morrissey, of course, the offense which was brought forward, there is never an easy or a non-aggravated form of causing the death of another human being, right? Somebody has to pay the weregild, the death price, and that's the nature of that particular thing. It's a very different circumstance in my submission than the circumstance at Barr, where Parliament has mandated the fact that there are small-time offenders and that it does cast an exceptionally broad net.
Mr. Derstine, I'm not quite sure that I'm following your argument about casting a wide net. As I read Section 84 about prohibited and restricted weapons, this seems to be a fairly finely crafted provision to which Section 95 applies, and it includes certain kinds of weapons. Looks like it's sawed-off shotguns and automatic revolvers and things like that that are unregistered and unlicensed. And it excludes antique firearms, weapons used for other certain purposes, and things like that. So it looks as if Parliament has taken a pretty fine look at this. It just hasn't thrown in every kind of weapon that exists. So I'm not quite sure that I'm following about this wide ambit that you're talking about.
I'm happy to be more clear, Justice Rothstein. What I meant about that is that the purpose and the effect and the rationale behind this law, and it's been excerpted in many of the written submissions which are before you, was to counter and combat the scourge of guns being used in criminal ways, right? That's the reason why it came forward. But into that net, and that's what Justice Doherty's point was, falls the regulatory. And falls the person whose criminal activity is enormously less than the criminal activity which fundamentally this legislation seeks to deter. And so that's why in my submission it can be said to cast such a wide net. Any statute in my submission that has everything from an absolute discharge to 10 years in prison is a matter which it casts a wide net. In my submission, the Parliament's intention about that could not be made more clear by its very enunciation of the sentence which it suggests is appropriate.
Well, I guess if somebody has a sawed-off shotgun for innocent purposes, by your reckoning, that's subject to this wide net.
It is, and I mean,
I wonder whether that's realistic. If we're going to talk about realistic hypotheticals, somebody has a sawed-off shotgun, unregistered, unlicensed. I'm not sure that it's so obvious to me that you can find a reasonable hypothetical that would exist that wouldn't be culpable.
That would not be culpable? Oh, it would clearly be culpable. I mean, any of the things that get enmeshed in this would be culpable. The question is whether they deserve 3 years in the penitentiary. Bear in mind, please, that during the course of the analysis of this section, that although it is predicated on the question of danger, danger is not part of the elements of the offence of this particular matter. Parliament could have said in a dangerous way or for dangerous reasons or putting people at risk or things of that nature, but it did not. There's no element of danger in this. There's no element of, for example, that the possession is other than transitory or other than quick. A person can literally handle a firearm for 45 seconds and be guilty of this particular offence. The Smickle facts, for example, although Justice Doherty found no favor with this argument, I'll try it out on this court. The question about somebody walking into a room, for example, and I'm changing the facts in Smickle a touch, but bear with me. Somebody walking into a particular room which belongs to a cousin or what have you who's a bad man, which is very much the facts in Smickle. He walks over there and says, oh, look, here's this firearm down there, and there are a couple of bullets, but it's unloaded. In Smickle it was loaded. That's the part that I'm changing. You walk in there and you say, hey, how cool is this? And you pick it up and you take a little selfie of yourself, and then you're interrupted 30 seconds later. Right? That's the nature and the extent of the criminal culpability which leads to that particular finding. In my submission, I mean, I'll address this head on, that particular question, that particular offender would be grossly disproportionate to sentence him to 3 years in the penitentiary. If that gun was unloaded, the fact that there are bullets that are rattling around on the table in front of him means that the sanction which should be applied to the person who left those things around is significant. But to the poor young dupe who picks it up and poses for it for a second before being interrupted, in my submission, he has not actually put anybody at risk. Bullets are not like amoeba that float into the gun and all of a sudden can discharge automatically. The question here is if he postures with this particular gun for a moment, which of us as young persons, perhaps not you guys, which of us as young persons has not done something foolish briefly in our lives, right? Did we all deserve to go to the penitentiary for 3 years for it? In my submission, it's grossly disproportionate even on that particular basis. So, I mean, and there's an example about a sort of a young urban fellow actually holding it, and it's not a sort of a rural cottage owner, so didn't find favor elsewhere. But in my submission, that would be a reasonable hypothetical that you could find and is closer to many of the reported cases in my submission. Although I have to pause for a moment and say that you should be very, very careful about the use of the charts. I say this very respectfully to my friends from the Attorney General for Canada, about using charts about reported decisions as some sort of empirical survey from which to conclude anything. The nature and the effect, these were not statistics which were put forward as part of any prior litigation. There's been no analysis of them. How it is that they came forward is still somewhat opaque. The question about whether or not they are accurate, whether or not they properly capture a broad range of what actually exists in Canada has not been tested, and in my submission has not been tested at all. And you should be very cautious before you should use them at all. Now,
you've been arguing that cases like Smithell and so on just show that this law can have grossly disproportionate effects. Why do you need the reasonable hypothetical?
The question about the reasonable hypothetical, and it's a useful point to get to right now. The question about the reasonable hypothetical is that to a certain extent, and this is an answer to what you said earlier, Chief Justice, is that to a certain extent, when one comes to constitutional litigation, where one's defense against the state is predicated on the fact of the unconstitutionality of a given law, the character of that litigation changes. It no longer fundamentally is the fact about only applying to you in my submission. To a very large measure, it applies to the question about the proper constitutionality of that particular section. And that, to a certain extent, is the question about Big M. Now, we could argue it based on the fact that that's an established principle, but you can also argue it based on a series of other principles. You can argue it based on access to justice, for example. It's not everybody who's going to be able to wield the sword of constitutional litigation. Many cannot. I included that case about Morrison, about that poor hairdresser woman who didn't want to bear the weight of constitutional litigation, so resigned herself to a 3-year sentence, where Justice Cole in the provincial court seemed very unhappy about the idea of wielding it. One of the reasons why it is that we do reasonable hypotheticals in my submission has to relate to a question of access to justice. But the other thing is, and I appreciate the question that by and large the common law tradition, generally in fact, the common law tradition is to decide things based on established cases. But to a certain extent, we have to move outside of that in certain cases for the reasons that we've put forward.
Well, my question is a little narrower. Doesn't it suffice to point to cases like Smithville? I don't deny the Big M principle, of course, or the propriety when it's necessary, and it may be in certain situations. But in a case like this, if you can show, just as a matter of methodology, if you can show that there are cases that might well arise where it would be unconstitutional, the Smith principle, is that not enough? And then why does a judge have to say, as a matter of law, I must construct a reasonable hypothetical with all the questions that arises? That's my question, not to go to the fundamental principle that a litigant can raise the impact of the law on other potential litigants. I accept that.
The question, if I understand your question properly, in my submission, it was most useful and easy way for the court to be able to consider the constitutionality is by dealing with other reported cases, or ideally other cases that are before them. That's the most and the best and the most ideal circumstance. The question is that that's not always something which is easily before a given court, and that's, in my submission, why it is that we turn to the question about the reasonable hypothetical.
I'm not being very clear, but what I can see turning to a reasonable hypothetical when it's necessary, but is it necessary in every case, and is it an error in the trial judge and the Court of Appeal not to consider a reasonable hypothetical if, for example, they were satisfied on the logic of Smith? That's my question.
In my submission, if it is that the case before you is enough for you to properly consider the question about the constitutionality, then in my submission, if the error that is alleged by the applicant is amply demonstrated by the facts that are before you, then you're fine. If the error that is alleged is not before you or cannot be shown by a case which is a compendious case, then in my submission, you do need to move beyond that in order to be able to properly express the constitutional principle and to give effect to the principles that we have. It would be preferable, in my submission, to refer, for example, to other reported cases, because they have all of the advantages that we have in actually having the actual applicant's facts be there. So it's preferable to use those, but that's not necessarily so. To a certain extent, the facts which are the applicant's facts in a constitutional litigation are almost as arbitrary as a reasonable hypothetical themselves. The reasons why it is that something, that a given case, why is it that we consider the Big M case in the light of, the Big M as an applicant, right? I mean, it's a kind of an odd thing. In Edwards Books, you consider the whole question about that, but Edwards Books didn't have anybody that was going to be disgruntled by the use of a Sunday sale. The whole question about the actual nature of the factual situation and how it is that it's going to be constructed is to a certain extent arbitrary itself. So in my submission, when you speak to the question about the potential arbitrariness of using other facts, you have to bear in mind the arbitrary nature of the facts of the litigant while you are considering a constitutional principle in general.
What is the function of the change that occurred between Smith and Golds, where we went from just saying, here's some examples or an example of a clearly disproportionate result, grossly disproportionate result. And then in Goltz, you say, no, we're going to tailor it more. We're not going to take any example. We're going to take what might reasonably happen under this law. And this concerned me in Goltz too. I dissented. You leave out the certain possible unconstitutional scenarios, and I never have understood why you would do that as a matter of methodology. Perhaps you can help me with that.
The question, again, I mean, it's a complex issue. In Goltz, in my submission, Goltz was circumscribed, was tailored in relation to its facts. It was a seven-day mandatory minimum, and so the facts which were being brought out in order to show that it was grossly disproportionate were really fairly abstruse facts, right? About the mother who was on her way with her autistic kid, and I mean, it's really hyper-complicated facts, and that's the nature of it. So this language came out about the fact it's got to be more ordinary. But it's well to remember when we consider whether or not there has been a fundamental change, that is that change so fundamental given the fact that Justice Gontier, for the majority in Goltz and in general in Morrissey, specifically said that example had not changed. Right? And it's well to remember that in Smith, there were no reported cases which recorded this hypothetical college student with the joint in his pocket, and nobody can remember there ever having been a prosecution about it. But that was not a bar even to Justice Gontier. So that while we consider this question, has it all been very much circumscribed, it's my fundamental thesis that it may have been circumscribed in certain ways, but has not really been circumscribed in the context of statutes which are of very wide application. It was criticized of the reasonable hypotheticals that they went a long way away or that they were abstruse. But the reality of it is that there are only so many ways that you can kill a person by criminal negligence with a firearm, by unlawfully firing a firearm. You can easily come up with 2 or 3 different ways where reasonably that can happen. But the same cannot be said with a Section 95 offense. It is just as broad, if not even more broad, in my submission, than the question of the importation of narcotics, which underlay Smith.
Do you agree with the Court of Appeal that you leave out personal characteristics at the second step, the generalized inquiry?
In my submission, no. I appreciate the fact that, we can, lead ourselves down some merry path by coming up with incredibly abstruse examples, but some examples to demonstrate that the person is at the bottom end of the range, for example, would be appropriate. It's perfectly reasonable to hypothesize during the course of a mandatory minimum, for example, that the person doesn't have a criminal record. That's not abstruse or strange, and it would really change the whole thing. If you had the leader of the Hells Angels with 19 horrible convictions and, he happened to just briefly touch a gun, we might not all recoil in horror at the idea of him going off to the penitentiary. On the other hand, if it was, Gandhi who walked in there and moved it a little bit to the left, maybe we'd be a little bit upset. So that to a certain extent, the question about the individual characteristics of the litigant are important. I appreciate the idea, let's just not go crazy about this, but importing certain things. And I specifically join with some of the other persons who are to speak after me with the idea that, for example, considering the person, for example, to have no criminal record, or to be from a disadvantaged background, or to be to someone to whom the principles of Gladue exist, in my submission, all have relevancy and cogency. And, you don't have to, go too far, but having certain ideas about why a person can reasonably be at the bottom end of the range are important.
I think this is important, though, from a methodological point of view, because, as Justice Doherty pointed out, proportionality is about the relationship between two things.
Yes.
And what I guess you need to help me understand is at the generalized inquiry level, what is on each side of that balance?
The generalized inquiry on my submission, in terms of the – sorry, I just want to understand your question.
We're talking about gross disproportionality.
Yes.
At the generalized inquiry, as between what and what?
The gross disproportionality between the actual level of the conduct and the sanction which is being levied. So that the and
level of the conduct is kind of code for a lot of different things.
It is the extent to which we can say you did wrong and the penalty which we levy against you. right? So that the extent to which you did wrong has a couple of different components. It is the actual nature of your act. What did you do? And it also has to do, to a certain extent, with who you are, right? I mean, those are the two fundamental questions that we answer on sentencing, right? I mean, what kind of a person are you? Is this, part of your character, or is it not? Is this the first-time offender? Do you have an excuse? I mean, not an excuse that would excuse it absolutely, but do you have a reason why it is you did it? Was it of a long duration? All those sorts of questions on the one hand, your overall moral culpability, if I could put it on the one hand, and the nature of the sanction which is being levied against you in keeping with that. And I take Justice Abella's point that one of the obvious difficulties with mandatory minimum sentences is, by and large, it doesn't allow for that sort of calculus. It does at the top end. You can, in a sort of a facile way, say, well, you can consider that in 3 to 10. But by and large, what that really means is that to the extent that you don't fall easily within what one would call the ordinary sentencing regime, those matters are of no moment because you get caught up in, as I say, this Procrustean bed where you get forced up into a given area.
So is the only thing the moral culpability? Is that the only thing on the second side? Obviously, on the first side of the proportionality is the sentence. I think that's not very controversial.
Yes.
And you're saying that what has to be grossly disproportional is the sentence in relation to the moral culpability?
To the moral culpability of the offender, yes. I mean,
so the amount of danger that's created is irrelevant?
Yes, I mean, but I meant, and perhaps I shouldn't have put it that way, I mean, it is the moral culpability of the offender. If one does a worse thing, one is more morally culpable, I suppose, is the other thing. If I actually put people in danger as opposed to not. For example,
you can kill people by pure accident.
What's that?
You can kill people by pure accident.
Sure. But, I mean, you have to be morally culpable to a lesser degree then, right? You have to be culpable to the extent that you do something negligently, which allows for it. If really you do it having no culpable state of mind at all, you're not guilty of it. The nature of your culpability need not be avertance. It can be inadvertence. But it still is a level of moral culpability. Intermixed into the question about that, I mean, I don't want to intermix into the question of that the question about whether or not there are proper penological goals, because in my submission that really doesn't come into gross disproportionality. Gross disproportionality is measured about are we hitting this person too hard given what he did, just to use a different form of analysis.
You just continue along that, because I'm still having some difficulty understanding why you cleave to the reasonable hypothetical given the scheme. We're dealing here with statutorily imposed sentences.
Yes.
Which is different from just the fitness of sentences and looking at the principles in 718, right?
Yes.
So if it's statutorily imposed, can you tell me why an individual assessment is even helpful if it's something that is a law?
I suppose the best way I could answer that, Justice Abella, is to...
And the corollary is why a reasonable hypothetical is even assistive in that context.
In my submission, it is to demonstrate that there are persons who would be affected in a wrongful and unconstitutional way by that particular legislation. It is to illustrate why it is that level is wrong. One cannot look at my submission at a construct in the abstract. We have to see how it is that it interrelates to people before we decide on those things. So,
you can look at the principle behind a mandatory minimum and say, in principle, this interferes either substantially or not enough, the justification process that we go through with every other statute. Can't you do that without looking at the particular circumstances and assessing the constitutionality of the particular scheme or provision?
you can, and maybe that's a good segue into my Section 7 analysis, which I've only got a brief amount of time on, but let me just bring it into there, because, Your Honor, you brought forward earlier the whole question about whether or not you could I've lost my train of thought. You brought forward earlier the question about whether mandatory minimum sentences per se might violate Section 7 during the course of an analysis. And to a certain extent, that can come forward during the course of Section 7. It's not the thrust fundamentally of this particular piece of legislation to go against all mandatory minimum sentences. And in fact, a good amount of legislative time in this particular court has been spent to a certain extent justifying them. Section 7, in a nutshell, if I can just have a second to finally get to Section 7, the question is that Section 7 cannot be seen to be some sort of pale shadow of Section 12, and that it has some other applicability. And by and large, just to reduce this to its nub, Section 7 protects against a number of other things which are not merely gross disproportionality. The gross disproportionality, which that was earlier commented on in Malmo Levine, was in the context of should we analyze the question of the sentence under Section 7 and what would the test be. In my submission, this Court has amply found that there is a question about there should be no arbitrariness in the imposition in any way that we deprive anyone of liberty, the no arbitrariness principle. And in my submission that has very real application to the answer to the question which you brought forward earlier, Justice Abella, and that to a certain extent the gap principle, the gap that is in Section 7, and I'll rely on my factum for the rest of this, interferes with that question of lack of arbitrariness, and that one can be extremely arbitrary while not necessarily producing a grossly disproportionate sentence, in my submission.
Can I just ask one question, Chief Justice? Of course. Just to follow along. We've been dealing with Section 12, and the case law is dealing with Section 12 in the context of sentencing. So we're all thinking of good idea or bad idea in connection with reasonable hypothetical in that context. But it doesn't just talk about sentencing. So I'm wondering, it's treatment or punishment, any cruel and unusual punishment. Does a reasonable hypothetical work in another context where we're dealing with treatment or punishment? Would we even be looking at a reasonable hypothetical if we were looking at, for example, solitary confinement? I'm just trying to think off the top of my head to get out of the constraint that we seem to have put ourselves in with Smith and Galtz in looking at this as a constitutional right.
Some of the circumstances which one could imagine, for example, a given practice in the southern United States, for example, there was a practice that was evolved about putting prisoners on what was called GRUE, G-R-U-E, and it was a horrible form of compressed food, and that they would be fed this for about 6 months, and it was raised as a form of punishment. And the court actually considered the question about whether or not punishing by using GRUE was okay. And that's a perfectly good example about a question of cruel and unusual punishment being raised on the particular facts of that case and not having to go any further. The difficulty is, to a certain extent, that that's a very specific example where the very facts of the litigant really illustrate the full nature of the problem. And the problem, to a certain extent, with different forms of statutes is that, and different forms of ways of breaching those statutes, is they don't so easily allow that.
But we don't need the reasonable hypothetical to figure that out.
In that case, no.
Thank you.
Thank you very much.
Thank you. Mr. Ripple.